Okay, good evening. My name is David Knight. I'm a software engineer. I work as an independent consultant in the field of data science. I'm also a licensed attorney. I'm a former litigator, primarily an appellate litigator, and I'm a former Army JAG officer. So somebody who's been involved in code since well before I went to law school, and somebody who works with data often, I am frankly obsessed with ways that data and law can intersect. So what I want to talk to you about tonight is something different from what you're usually used to hearing. When lawyers talk about data, typically they're talking about it in one of two contexts, either data privacy and data security or legal analytics, like predictive analytics. Can we analyze court cases and from that judge whether a case is likely to succeed or an attorney is likely to perform well in front of in a certain court or what have you? I'm going to talk about how tech companies and people like myself use data to optimize digital products and how, as attorneys, you might use some of those same techniques to improve your work product and what that might look like further in the future as well. So I'm going to start it with an experiment. I want you to take out your phones and type in that URL. It's going to take a second to load because this is a prototype application being hosted on a server that is deliberately slow. You don't need to know what that means. Just don't freak out if it doesn't load up right away. And don't press anything once it loads. If for some reason this doesn't work for you at all, just sit tight. It's only going to take about 5 minutes, but come up to me afterwards and let me know so I can see what kind of device you're using. So I channeled my inner bar examiner and I gave you a scenario. The scenario is not very important. You're basically being asked to look at a short open source license for software. I'm not trying to hide the ball like in law school. But I'm going to ask you 10 questions that should be very straightforward. You're really just being asked to fetch some things in the document. And after you finish the 10th question, you should get after a brief pause, there should be a pop-up that says how many you got right, and then click OK, and it'll take you to my website where you can then read really dry and technical articles about functional JavaScript until everybody's done. So let's take about 5 minutes to do that and start now. So congratulations, you just completed what is almost certainly not your first A/B test, but maybe the first one you were aware of. So some of you, hopefully about half of you, got version A and the rest of you got version B. A/B testing is a technique that we use in the tech industry to test the effects of design decisions on user behavior. I did a couple of different things to test a hypothesis, which was if a document is well designed, it's easier to find the information you're looking for. So in version A, I did everything right from a design perspective. I use a lot of white space. I break up sections visually. I add section headers. I use an icon and subtle use of color to draw attention to a couple of things that are important. Each defined term is clearly separate from the body of the text. Version B, I did everything in my power to make it as difficult as possible to find what you needed. So I made the text smaller. There's no white space. There's no paragraph breaks. Everything is a big jumble. Depending upon which device you're reading it on, things could be in different locations. I made it unnecessarily formal, as some lawyers do, by capitalizing all of the defined terms. I even included a huge block of bold all caps. So I was testing a couple of things. One was whether the code works. Was there anybody for whom it didn't work at all? Good. Okay. It makes me feel better about myself. The second thing, obviously, was testing my hypothesis, which is whether design has a measurable effect on how lawyers interact. I was also measuring how long you spent reading the contract initially, whether lawyers tend to read a contract and then look at the questions and then review, or if they just jump straight to the questions and then go back. That sort of thing is easy to tell. I timed how long it took you to answer each question, and obviously I also am recording the scores so I can see which types of things are harder to find or which pieces of information or which questions are less clear, so I can improve the test moving forward. But what might not be so obvious is that I was also collecting data about your devices using a tool called Google Analytics, right? So Google Analytics is about half of the world's, a little bit over half of the world's most popular websites are running this tool. This is a form of tracking software. Tracking software has been around since the 90s. If you remember, websites used to have these little counters on the bottom that would show how many visitors were there, if you remember. If you're old enough to remember that. That was tracking software too. It just wasn't as robust as Google Analytics. So what Google's doing is, and we don't need to get into the weeds as to how this works, but what Google Analytics does is it records your device, your operating system, your location, your IP address. If you came from a different website, which none of you did because you typed the URL in directly, but if you had come from a referral site, it would log that. It will note whether you came from social media. It'll track which pages, if you were on a multi-page website, which ones you visited, how much time you spent on each of those pages, which links you clicked on. It also tracks other websites that you visit. So while it doesn't know who you are individually, it's able to piece together a profile of the type of person you are based on the websites you visit and how you interact with them. So with that kind of information, and in addition with the benefit of neuroscientific research, we know a lot of things about how people interact with written documents with digital media. For example, we know that most people are visual learners. Most people don't like to read text. They would much rather look at things like pictures. And just on a side note, given that most people like to see pictures, think about what that says about the way that we learn in law school. If only 1 out of 3 people is an auditory learner, and you're sitting in lectures all day, it might explain why you may have zoned out a lot in law school. People prefer movement and colors and different, our brains are hardwired. We have evolved to notice things like that, like differences in size, for example. Who, when I opened that slide initially, saw the airplane or the head first, and then the text later? Okay. Airplane. Who saw 60,000 first? Yeah, some people go to that too, right? Who saw fast plane first? Like nobody, yeah, nobody ever does because we're evolutionarily programmed to look for other things. And the reason is that reading is hard. It taxes our brains. It takes us 60,000 times more energy to process written text. So because reading is hard, people don't read. Anybody, and this is true of lawyers as well. I know you're thinking that surely we must be different, not borne out by research. This is a heat map from a user tracking study done by one of the large tech companies a couple of years ago. And it shows that when people look at a written document, whether it's in print or it's a website or an app, they go to the top left corner, which makes sense because we read from left to right. But we get bored really quickly, or our brains get tired really quickly, and we just sort of scan. And we scan in an F-shaped pattern. And then we tend to go down along the left side of the main column and read the first 1 or 2 words, and by the end we just trail off completely. So knowing things like that, that's how people interact, what tech companies will do, and what you might want to consider doing as an attorney who produces a lot of written documents, is make sure that important information is in the areas where people are naturally going to look. So for example, in version A, I structured the document to fit that F-shaped pattern. All of the defined terms are up against the left-hand side of it. So if you were looking for the definition of a contribution or a contributor, it should have been easy to find. Whereas in version B, you had to dig through a wall of text to find what you were looking for. Another thing that we know from data is that, and studies, is that when the human brain sees a word, the first thing we see is actually the outline of the word. And we're looking for visual clues, because the brains are lazy. So we're looking for visual clues to figure out what the word is without having to read the letters. So when you write something in all caps, it can be difficult to fill in that gap or to recognize the silhouette of the word because all caps are rectangular in shape and most letters don't give you a lot of clues as to what they are. Whereas if you do it in lowercase, it's easier to figure out what the word is. But this problem is amplified if this is a large amount of text instead of a single word. So if you write something in a wall of all caps, bold text, it's very hard for your brain to read that. So strategically, if you want somebody to read your writing, don't use all caps. You don't want somebody to read the terms and conditions. You might want to use all caps. Ethical issues may be there, but that's outside the scope of this talk. We also know that there is such thing as an optimal line length. So it's around 60 characters, give or take 15 characters. So if you've ever had to, like I was an appellate attorney, so some courts were very particular about the margin and the font size. And I used to not really understand why that is, and I realized that they figured this out. They know that if a line is too long, it's difficult to read. and you have to read a lot as an appellate judge. So they enforce that. Anything beyond about 75 characters and people trail off. And again, that's reinforced by the heat map that I showed you earlier. So the contract that you read was just over 300 words, and the average sentence length was about 18. The longest one was 49 words. If you got version A, any sentence over that started to get too long, I broke up into bullet points whenever there was a list of things, because those are easy to read. If you had version B, I'm sorry. But we also know from data that sentences, well, that there's a direct correlation between the number of words per sentence and reading comprehension. These numbers are actually taken from a study specifically of lawyers, and we found that anything with 14 words or less is very easy to read. Anything over 25 words is hard to read. By the time you get to 43 words, you've lost almost everybody and has to be reread multiple times. It's another thing to think about when you're drafting documents. So these are things you don't really learn in law school. And why is that? It's partly a product of technology. The average partner is in their mid to late 50s. The average judge is a little bit older. A lot of decision makers and the people who are training younger generations started practicing law when computers were not what they are today. And going back to when I was a kid, computers were basically just glorified typewriters. And even today, most people don't use software like Microsoft Word to its full potential. So moving forward, I kind of want to just talk about some potential ways that the practice could change to leverage the types of things that I just glossed over today. We know that 90% roughly from the last ABA Tech Survey, 90% of attorneys use their cell phones for work. But almost none of them use it to read legal documents, whether it's a contract or a brief. And why is that? Anybody want to venture a guess? Yeah.
Too small?
Yeah, and why is it too small? Because it's usually a PDF, right?
Yeah.
Yeah, and PDFs are not responsive. Responsive just means that it'll adjust to the size of your screen and adapt. PDFs are basically a photo of a print document, essentially. That's what it is. So you have to zoom in and scroll around. It's difficult to read, and it's time-consuming. The technology has been around for a very long time to, for example, export a document as an HTML file that can then be opened in a browser and easily read. There's nothing in the rules stopping you from sending a courtesy copy as HTML of any document that you create. Right? And if we started doing things like that just to make it easier to read, there's a flip side to that. And the flip side is what I did to you guys earlier. Imagine if you had the ability to track user behavior with respect to your legal work products. So what this is right here is another visualization from the Google Analytics dashboard. This is called a Sankey diagram, and what these do is they show the flow, how users move through a website. What it's showing is that of almost 3,000 visits to this particular site, about half of them came from an organic search, meaning Google or Bing or whatever they use. And then the rest came from other sources. And most of those people landed on the homepage. Some of them landed on careers. And people who came from social media, for example, tended to go to the career page. And then from there, it would filter down to secondary and tertiary pages. Imagine if you had the ability to know which page a judge started reading your documents on. And again, I'm using litigation as an example because that's my background, or a contract. Imagine knowing if the judge even read your brief at all. Or if they did, how much time did they spend on this argument versus the other argument? Did they click on, pause. If we used HTML, then we could also use JavaScript, which is what adds interactivity to websites. So you'd have the ability to toggle citations on or off, to highlight things, to highlight the names of the parties to make them easier to find, to collapse different sections so that you can find things or refer to things more easily. Pretty much anything you can do with any other website, you could do with only a small amount of coding knowledge, or hopefully a tool that does that for you. And then you would know that. You would know the clerk looked up these specific cases. The judge never read this document. When I was in practice, I've been before judges that clearly hadn't read like some key case in my brief. It's very frustrating and uncomfortable. I would have liked to have known that in advance. There are ethical concerns, though. I don't have the answers to those, but that's definitely something to think about. The takeaway is this. If you can be reduced to data points, whether it's through data information about your devices or how you interact with sites, then you become predictable. And once you are predictable, you can be manipulated. So that's all I've got. Thank you.
Do you want to take questions?
Yes. Yeah, let's do that. Okay. So questions. How many people got version A? Okay. You got, okay. So all of your scores got sent to me. I don't know who you are, but I'll get your scores, and I will analyze them, and then on Twitter, I will post about any findings, anything meaningful that I can find. I can tell you from the last time I gave this talk that people who got version B almost never read it. They just immediately skipped to the questions because it was too overwhelming. And they did much worse on the questions. So there was a measurable effect. Anything else?
I really saw that F pattern when I initially first saw it. And thinking back to it, I was just like, all right, let's get to the questions. I did get version 8. I did see the first bullet points, went to the definitions, and then just died off as I went into the page. I was like, all right, I'm ready for the questions.
Yeah, I mean, that's just how everybody reads. It's just we're trained to read that way. So what a tech company will do is, if I'm selling a product, right? Depending upon how you came to my site, I might show you a different product. Depending upon how Google has classified you as like the demographic you fit into, I might show you different things. I mean, everybody knows about Cambridge Analytica. Everybody knows that Facebook and other tech companies give you targeted advertising. But I might also strategically position a button or reword a heading or something to make it more likely for you to click on that. Because we're all being manipulated constantly. It's not necessarily always nefarious, though, because the technology that allows something like Google Analytics to record your browser and your screen size is necessary to create responsive documents if it's baked into the technology. So if we weren't able to get that information, the web would be like it was in the 90s, where everything was static and there was no adaptation. Yes? Yeah, you.
Okay, so when it measures the heat, if I have my finger on my phone over here and I'm looking at it over here, how does it measure the heat from my eye and not my finger?
So the way that heat map worked, it's a good question. Yeah, so what they did in that study was that they triangulated, basically they had cameras on the participants and they triangulated where on the document they were looking based on where their pupils were.
Yeah. So there's no heat map for you.
Yeah, so when we do user, yes, I don't have heat maps. Yeah, that was a much more complex study, right? When you do user testing, for example, user testing is kind of like I'd bring in a group of people and we'd give them a device and we'd say, I want you to go to this, open this app or go to this website, and I want you to do this task. And then we just observe them performing the task or trying to perform the task, and we ask them questions, kind of like you're in a deposition or you're doing an examination of somebody. You're asking them to explain their thought process without guiding them. And one of the tools that we will use is to record their expressions, because you can learn a lot about people based on just how confused they look when they're interacting. But triangulating where they're looking on the screen requires a lot more resources than that.